Hi, this is Jim Cunningham. We're going to talk about special needs trust, a lifeline for your loved one with special needs and their future. So, very important to many clients. Many of our clients do have loved ones with special needs, whether they're children or grandchildren or nieces and nephews, maybe even siblings. So, we cover that. We've covered that in other webinars, but I kind of want to give a high level view of what a special needs trust is and the new laws. So there's been a big change, especially when it comes to IRAs. And I really we're going to cover that toward the end on the retirement accounts, the IRAs and 401ks. But what and who is a special needs trust for? So why are these out there in the ether? And we're doing a webinar format, and we have a question here. And I'm going to lead with this because this really is kind of what we're going to be talking about. My son is a disabled adult. He lives independently and has a job. I am his power of attorney and handle all his finances. How do I create a trust and bank account for him for savings? Great question. So a lot of this is going to be special needs trust. Now, that may be a first party special needs trust, and we'll talk about that a little bit. We're also going to be talking about what we call third party special needs trust. But the bottom line is a special needs trust, whether it's a first party or third party, it's whether the loved one with special needs creates that or another loved one creates that, right, for the individual with special needs. The idea is to maximize the quality of life for your loved ones with special needs, to provide money and other in-kind support. Now, some in-kind support is not permitted. Food, clothing, and shelter traditionally are the ones that are not permitted, but other in-kind support without disqualifying this person that you really care about deeply from governmental benefits. And what we're talking about here is SSI, Supplemental Security Income, and really protecting that benefit. And not just the monthly check. There's also Medi-Cal in California, Medicare. There are also other benefits that you may get depending on where you live in the United States. And the idea is to preserve those benefits because if you have too much in assets, you get kicked off. So these are needs tested or needs based public assistance benefits. Basically, if you have over $2,000 in California, they say you don't need it and you lose a lot of benefits. So it's very important to pay attention to this. And the idea is to manage something that you may give to somebody, a loved one during your lifetime or after your death, to manage those assets to protect them, not only preserve government benefits, but protect from predators and waste. So that's a real big concern. A lot of people say, I don't want these assets just kind of used, kind of stolen basically, or wasted. So these are some questions that you might have if you do have a loved one with special needs and you're thinking about doing this planning, or if you have done the planning, you might be reviewing it. Who's going to care for this person that you care about, right? When you can't. Where is your loved one with special needs going to live? And we meet with many clients who have outlived, quite frankly, or thought have outlived their child in the sense that they lived a lot longer than they had been told back in the day when their son or daughter was born decades ago, right? And what happens is people have a lot of anxiety. They say, what's going to happen to my son or daughter when something happens to me? This person's been living with me my whole life. What is the next step for that person? Because I'm not going to stay here. I'm not going to be on earth forever. Who's going to make healthcare decisions? Very important. Who is going to handle the money? Now, this could be a large amount of money or a small amount of money. What oversight is going to be in place? So someone's handling the money, but who's kind of watching the handler of the money? We'll talk about some methods and some approaches to deal with. Really, a lot of people are concerned. Look, I've got this loved one with special needs, and someone else is watching the money. What's to keep them from stealing it or misappropriating the money, which does unfortunately happen. What about are there special rules for your IRA and your 401k? So these pre-tax dollars, we're not talking so much about Roth, but tangentially Roth, we'll talk about that. But if you have an IRA or a 401k, you haven't paid taxes on that money. And so at some point, taxes will have to be paid. The question is, are they paid kind of all up front, or are they paid over a longer period of time? And we'll have an example here on the difference in dollars, not only for your loved one with special needs, but other family members as well. And what about income and capital gains taxes? How do we deal with these issues, right? If it's a larger special needs trust, then we do have to pay attention then. And who will maintain the client status at the regional center? So these are publicly funded centers for individuals with special needs and developmental disabilities. And it's really important to stay connected with that because, it's another bundle of social services. So I'm Jim Cunningham. I've been an attorney for 30 years. We have offices throughout California. I'm a certified specialist in estate planning, trust, and probate law, a securities insurance license, and a real estate broker, pilot single engine land, instrument rated, not current. And so I've been doing this a long time, and we have a slide in here about the benefits of having a lot of experience, and then that is sometimes isn't a good thing, and I'll explain why. So these are the attorneys in our firm. We are dedicated to all things estate planning, wealth creation, preserving benefits for loved ones with special needs. And we work together as a team throughout the state of California. It's very important. I'm a lawyer. I'm talking, words are coming out of my mouth. This is absolutely not legal advice. So legal advice is one-on-one with a lawyer. And this is really, really important because this is such an esoteric area of law. This really is a subspecialty within a subspecialty. So trust and estate attorneys specialize, or they focus in one particular area. And then you have this subspecialty within estate planning, which is special needs planning. And this changes from time to time. And what you're going to see with the IRAs and the 401ks is there is an intersection, which you rarely see, which is somebody who has an understanding of income taxes and IRAs and 401ks and special needs trusts and the unique tax attributes, because a lot of times the tax people don't know the public benefits planning. The public benefits planning people aren't really aware of the taxes. So our offices are located in Northern and Southern California, in the Bay Area, Capital Region, and Los Angeles area. So what is a special needs trust? Well, a special needs trust is a trust. So it's a document, it's a bucket that you put assets into. Now you can do this while you're alive. You can do it after you pass away. You can create a bucket while you're alive that other people can put money into. And this is really important. So if you have a child with special needs, and you have a parent who wants to make a gift to your child, what do you do? I mean, do they give it to you and then you leave it to your kids, your child when you pass away, or do you set up something while you're alive? So these are this is kind of the fork in the road. And when we have that consultation with someone who's interested in creating a special needs trust or some type of planning for a loved one with special needs, this is kind of the first thing we talk about. Is this something you want to set up now? Is this something you want to set up after you pass away? But really, the idea here is it is a specialized trust that allows a pot of money to be set aside that does not kick your loved one with special needs off of public assistance benefits. And the big ones we're talking about here are SSI and Medi-Cal. So that is supplemental security income and Medi-Cal. Those are two needs-based public assistance benefits. The other big one is SSDI. This is Social Security Disability Income. We're going to talk about this a little bit later, but do know that if you have supplement Social Security Disability Income, there really isn't a need for a special needs trust. The reason is SSDI essentially says you've been in the workforce, you can no longer work, and so you're getting paid from what amounts to an insurance fund, right? Because you've already paid into it. And the only constraint is you really can't work, is the bottom line. So SSI may also have some work rules related to it, but understand that broadly speaking, if your loved one is receiving SSDI, we're typically not going down the path of a special needs trust. It often is too restrictive. So your goal is to maintain the beneficiary's eligibility. So this would be your loved one with special needs, maintain their eligibility for government benefits, while also providing funds really to improve quality of life is what it's about. So a lot of people are concerned that the available public assistance benefits won't adequately meet the need of the loved one that they have when they leave this earth and their loved one stays behind. Is there enough money to properly care for your loved one with special needs? So how does a special needs trust work? So what we're talking about here is this is oftentimes it's a parent who sets up a trust for a child, this child with special needs. And when that money goes into the trust, that money can be used for things like education, medical and dental, personal care attendance, vacations, hobbies. It typically is not used for food, clothing, and shelter. That compromises the benefits. Sometimes we permit that in certain limited contexts if the special needs trust is very large. But broadly speaking, just know going into this that food, clothing, and shelter is a carve out. So that's just something that, the idea is that your government benefits are supposed to meet your basic needs of food, clothing, and shelter. So there's a trustee who's not the special needs, the beneficiary, right, with the special needs. So if you have a son or daughter who is disabled, cognitively fine and able to be trustee, that person cannot be trustee of a special needs trust. So very important, you have to have a third-party trustee. The beneficiary cannot have direct access to the trust if they're if they're receiving SSI. So very, very important because that can affect their eligibility. So let's look at Abel. Abel's a 30-year-old man with developmental disability. He receives supplemental security income and Medi-Cal. Abel's parents fund a special needs trust with $600,000 from their estate, which includes life insurance proceeds and savings, to be managed by a professional trustee. With a properly structured special needs trust, the $600,000 that goes to Abel Abel keeps his public assistance benefits and doesn't lose them. So even after Abel's parents are gone, the trustee of the special needs trust can pay for a computer, internet, online games, whatever Abel's, what he likes, maybe trips to Disneyland, a personal care attendant, and provide a structure to ensure that Abel is properly cared for. And we're going to talk about that structure, mechanically how that works, in a few slides. Delta is a 14-year-old girl with a physical disability that requires her to use a wheelchair. She's got supplemental security income and Medi-Cal. Delta's parents fund a trust with $600,000 and name themselves as trustees. Again, this $600,000 with these funds, Delta can keep her government benefits and use the funds for extracurricular activities, Special Olympics, or adaptive dance classes, fund home modifications such as widening doorways, installing a stair lift, or pay for any service animal costs or vaccination or vacations. So again, using it for something other than food, clothing, and shelter. Now, whether you should do this if you have a 14-year-old daughter or not, case specific, but broadly speaking, we're just giving you an idea of what a special needs trust does and how it works. Now, this can be funded now, can be funded after your passing. So there might be reasons to fund it now. There might be reasons to fund it after your passing. Again, this is what with the one-on-one with the attorney. So there are two types of special needs trust. Primarily what we're talking about here, certainly when it comes to IRAs, is the third-party special needs trust. But there is something called the first-party special needs trust, and this is funded with assets that belong to the trust beneficiary. So this is the loved one with special needs. So often these are personal injury settlements. Sometimes they're inheritances. Or other type of settlements. PG&E in Northern California, there were a lot of fires. A lot of people are getting settlements. And some of those people who are getting settlements are on SSI, and they're on needs-based public assistance benefits. So that may be something where we would do a first-party special needs trust to make sure that that money does not kick that individual off of public assistance benefits. So this can be established for a disabled beneficiary under the age of 65 for what we call a D4A trust, which we're not going to talk about a whole lot, or of any age, and that's a pooled trust for a D4C trust. So there is an age cap on that. And again, what we're going to be talking about here is kind of a higher level discussion of special needs trust, really focusing on third-party trusts. So these are typically funded with assets that belong to someone other than the trust beneficiary. So this would be your loved one with special needs. It's often parents, grandparents, or other relatives. This can be established by anyone, right? Parents or grandparents at any time, and is not age restricted. So much more flexible. And there are some other attributes to the first party special needs trust, which the big one is a payback requirement, right? If you set up a special needs trust, any remaining trust funds have to be reimbursed to the state for any Medi-Cal or other public benefits upon the death of the beneficiary. So the idea is a first party special needs trust, you'd probably want to draw that money down during lifetime, because whatever's left in there has to go back to pay the benefits. There is no payback with the third party special needs trust. So a very high level, if you're thinking, gee, what's better, a first party or a third party? Well, a third party is probably better in most cases. But if that money is already the individual beneficiary, the individual loved one with special needs money, you're probably looking at a first party special needs trust. That a first party can require court involvement and supervision, certainly if that individual is cognitively impaired or not able to create a trust. And these assets are not counted as the beneficiary's assets once they're funded into a first party special needs trust. There are fewer restrictions on the management and control in a third party special needs trust, and also the assets are not counted for public assistance benefits. When is it time to consider a special needs trust? So if you have a loved one with special needs, when should you be thinking about this? Like, is there too soon? Is it too late to think about this? But broadly speaking, supplemental security income pays a monthly benefit to people with limited income and limited resources who are disabled, blind, or age 65 or older, and including blind or disabled children. This is means tested. It means essentially the person really is unable to work. Dolly, a minor, lives with cerebral palsy, receives SSI, is disabled at age 18, and will continue to be medically eligible for SSI and Medicare so long as her assets and financially eligible so long as her assets stay under 2,000. Dolly's parents create an estate plan with special needs trust provisions so that Dolly's provided for, but keeps her SSI and other government benefits intact. And without this planning, Dolly loses the benefits. It's very, very important. Now, could Dolly do a first party special needs trust after? Perhaps. Okay. But again, there's reimbursement, right? So very important. When is the time to think about this? If you are planning for the individual, the loved one with special needs, the time is now because you don't know how long you have on this earth. No, we just don't know. And things can happen. You may have a very long, productive life. You may not. We just don't know. And the whole idea with estate planning is it's something that may be off in the future, that really there's no urgency, right, for most people, but it is going to happen. And what we find, typically the people who meet with us who do have loved ones with special needs, they tend to kind of have their stuff together, right? Because you have to, oftentimes caring for typically a disabled child. So we see clients coming in when the children just before or before they turn 18, oftentimes after they turn 18. And there are a lot of other reasons why you might want to have things set up before age 18. Certainly if you're going to get a conservatorship, because once that child reaches 18, they're an adult. So what happens is and the regional center typically prompts people on this. As the child is looking at turning 18, that's when you start looking at the conservatorship proceedings, which is kind of outside of the scope of what we're talking about here, but something to be mindful of. Not every person with a disability needs a special needs trust. So we talked about this. If you have Social Security disability income, that is for people who were working, who have paid into the Social Security disability system, and have become disabled after working. This is not means tested, but you essentially can't work. So Tom, a long haul trucker for 20 years, suffers a back injury and could no longer work. He's now on Medicare and receiving Social Security disability income. There's no special needs trust needed for this type of disability or government benefit. So if that's you and you're going on SSDI and you're watching this video, you're like, well, do I need to set up a first party special needs trust? The answer is probably not. Now, I'm not going to say no because, right, I'm not giving legal advice, but typically people with SSDI are not setting up first-party special needs trusts. You need to really think about creating the right plan for your loved one with special needs. So when it comes to loved ones with special needs, it's vital to create a comprehensive plan to care for them when you're gone or incapacitated. So what kind of trust, should you do and what are the crucial issues? It's not just about the money, it's actually caring for the person. So I think sometimes estate planning attorneys fall into the trap of thinking it's all about the money, but ultimately it's not about the money, it's about the people, right? So it's the who's, it's not the how much. Let's look at some insider tips on making sure your wishes are carried out. So what can you do? Well, there are some benefits and drawbacks of 30 years of experience as a lawyer. So I have 30 years experience. Here's the problem with this. I'm not going to be around forever, and I have the experience. So if you're watching this on YouTube, we have a little cartoon here, a little infographic. Sorry, we're looking for someone age 22 to 26 with 30 years experience. So this is a bit of the paradox. This might be a little bit of cognitive dissonance where two things are true at once. You probably should be seeking somebody with significant experience when it comes to estate planning. The problem is the people with significant experience will not be around, aren't going to be around, right, to help administer this trust in the coming years and certainly coming decades, because these can last a very long time. One example we're going to have is a 25-year-old beneficiary who lives another 60 years. I'm not going to be alive in 60 years, okay? But this trust may be around in 60 years. So I would say, this is kind of like picking the firm. This is who should you pick to do this? Well, I would say consider a firm that's going to last. Now, in our firm, and you might have seen this in the picture of the attorneys, we have diversity of age. We have a succession plan in place for our law firm. So when I'm not here, there will be other lawyers taking over. And I would not underestimate the value of institutional knowledge. What do I mean by this? Well, matters that we worked on, oftentimes we're touching those matters every few years. There's a record of what we talked about. There is this institutional knowledge that is very hard to transport from one firm to another. So this is just a little bit of insider tip, just something to think about when you're looking at hiring a professional. And I would say probably more than any other estate planning, you want to work with a firm. This is really not estate planning is not a do-it-yourself project. This one really isn't a do-it-yourself project. And as you're going to see, there are a lot of considerations beyond just the special needs trust. Now, I'm going to give you a little bit of a secret. The guts of a special needs trust are about 4 pages long. This is the federal language that has to be in the trust. Very short. A lot of other stuff that's in there doesn't have to be in there, but is helpful. And also you need the structure of the trust. So it's not that these are 4-page trusts. It's just the language tends to be about 4 pages that absolutely must be in a trust in order for it to be a special needs trust. And a lot of these trusts end up being 100 pages because there's a lot of other stuff in there. But understand that not all special needs trusts are created alike. So some provisions of a special needs trust absolutely should be in the trust document, the 4 corners of the trust document, and other provisions or other instructions or other teaser letter of intent should not be in the trust. And I'll kind of walk through why. Many people who have a special needs trust do not have a care manager or an advocate or an advisory committee or a trust protector, okay? I think after you listen to what I'm about to tell you, you might think it's probably a pretty good idea to think about having one or more of these 4 roles in the trust. I'm not saying you should, okay, this is very important, but think about it. You might not need a care manager, right? If your loved one with special needs is not cognitively impaired, you may not need a care manager. You may not need an advocate or advisory committee, right? But typically what we see is clients who have a loved one with some type of cognitive impairment. It's very important to consider this. Now, again, doesn't have to be in there, but these are, again, they're not technical requirements of a special needs trust, but they can be useful. So an example is a trustee might need assistance in making distributions to comply with benefit issues, right? And in meeting your wishes. They might need to rely on people with technical knowledge about the benefits that your loved one is receiving. And many times that is not the trustee, okay? So certainly if it's an institutional trustee, some institutions do have special training with special needs trusts, but many don't, right? And they do rely on third-party experts because the trustee is typically an expert in being a trustee, not necessarily an expert in public benefits law. So care managers and advisory committees can provide checks and balances vis-a-vis the trustee. This lessens the chance of trustee mismanagement, right? Or not making distributions, even though it's in your loved one's best interest. So this is really important. A trustee says, no, I'm not making a distribution for that new TV. You know, that's a waste of money. And your care manager and your advocate and the advisory committee might say, no, in fact, we're going to direct the trustee to buy the TV, right? So that's kind of a trite example a little bit, but the point is you can have these other people who know the loved one with special needs probably better than the trustee does, right? It depends on who the trustee is. And then certainly a trust protector. And we talk about that in a lot of other contexts, but certainly within the context of a special needs trust, I think it's important to consider that. If you have an estate plan or a special needs trust that does not have any of these roles, you probably need to have that reviewed. I would definitely take a closer look at that. So a care manager in a special needs trust can help your loved one. How can a care manager in a special needs trust help your loved one with special needs? Well, coordinating services and care. The care manager can be the boots on the ground person who is making sure that your loved one is properly taken care of, monitoring the health and housing and daily living needs. Is the place that the person's living in, is it still optimal, right? Is it a proper place to live in? Ensuring receipt of appropriate medical care, therapies, and support services. You know, I think back on my wife taking care of her parents as they aged before they passed away. There's a lot of coordination of medical care, and for many of our clients, their children or grandchildren or loved ones do require some pretty complex medical care. And again, you know, this may not be in this may not be in your situation, but if it is your situation, it's probably resonating with you, right? I want to make sure that my child gets the proper care. And then acting as a liaison between the trustee and other third parties to facilitate smoother communication and better care. We see that a lot with the care manager. They might be the one, they're sort of managing the process of making sure that the human, right, who is the loved one with special needs, like this human being that you care so much about, gets the proper care. Again, a trustee may not be up to the task to do that. Doesn't mean that the trustee is not a great trustee. Now, you might say, well, I'm going to pick a trustee who's a great care manager and a great trustee. That may work, okay? It also may not work, right? Because if you don't have that carved out role, your trustees can change, and depending on how trusts are written, a departing trustee might be able to appoint a successor trustee. Well, that might work for you. It might not work for you. Again, this is the one-on-one counseling that we do with clients when it comes to these issues. An advocate in a special needs trust can help your loved one with special needs. How? Because the advocate represents the interests of in the legal and administrative matters of the trust. So care managers looking out for the loved one with special needs. The advocate is saying, look, Abel cannot advocate for himself. I am designated in the trust to advocate for Abel. This could be a sibling. It could be an aunt or an uncle. It could be a best friend. It could, you can put in there whoever you want, right? And so this helps ensure that the rights are protected under federal and state laws. And this can help in navigating government benefits such as Social Security, Medicare, and Medi-Cal in California. So Medicaid is the federal program, Medi-Cal is the California implementation. And also speaking on behalf of your loved one with special needs when dealing with service providers and government agencies. So that can come in handy. Again, sometimes, could the trustee be an advocate? I suppose, but a trustee has a duty to carry out the terms of the trust as written. And sometimes the terms of the trust as written aren't working, and those need to be changed, and we'll talk about how to do that. It's very important. If you're in California and you have a loved one with special needs and you set up a California special needs trust and your loved one moves to Oregon, that changes things. That special needs trust probably going to have to be modified, okay? And if it's an irrevocable trust, you either have to go to court or, as we'll see, you can use the trust protector. So again, a lot of people aren't necessarily thinking, well, gee, when I'm gone, yeah, my son or daughter might end up moving to Oregon to be with their sibling. Yeah, that's going to change things. And I think it's important to build into the plan the flexibility to adapt to changing laws, right? I mean, certainly laws can change at any time, but the ability to change the estate plan or the trust to adapt to laws, again, to preserve the government benefits. The advisory committee, right? We see these quite a bit. A lot of times when you have a cognitively impaired person. So a lot of times the care manager, advocate, and advisory committee is when you have somebody who doesn't have the ability to advocate for themselves. This provides input to the trustee regarding your loved one's needs and preferences, right? So the advocate advocates, the care manager manages the care, but you might have an advisory committee that says, we really know the beneficiary, the loved one with special needs. They typically have a close relationship, and they can say, look, we knew the parents and we knew what they wanted for their son or daughter. And so the housing choice that the advocate is advocating and the trustee is willing to do, we've all agreed as the advisory committee, that may not be the best thing to do. And I want you to understand that ideally, this is not an adversarial relationship. This is where the advocate listens to the advisory committee. The trustee considers the advisory committee because that's the way the trust is written. And ideally, there's no conflict. People are heard and ideally there's no conflict, but there's a way to avoid it, by the way, with the trust protector that we'll talk about. Who's kind of the arbiter. But the advisory committee can offer recommendations to ensure the trustee is aware of your loved one's best interest. So it's to make the trustee aware because a trustee has a duty not only to the trust corpus or the trust assets itself, but also to the beneficiary. So they've got to carry, and they frankly have a duty to you. If you set up this trust, the trustee is obligated to carry out the intent of you who created this trust. That's about 1,000-year-old rule in Anglo-American law. So this comes from England, and the idea is to carry out your intent. So trust protector role in a special needs trust and how it can help. So what is a trust protector? A trust protector is typically an individual who has power over the trust, but is not the trustee. So a trustee must follow the terms of the trust as written. If the trust says, you're going to go from Southern California to Northern California and take Highway 99, or the 99 if you're coming from California, because that's what you would say, Southern California. And that was, if let's say the trust is written before Highway 5 was built, right? Or the 5 was built. And you would say, gee, well, we don't want to have to go up the 99. It's a pain. It's going to take longer. It's going to take more gas. We'd rather go up the 5. The trustee has to follow the terms of the trust as written. The trust protector can change the 99 to a 5, right? So that's what we're talking about is a trust protector, changing a trust that is irrevocable. So your revocable living trust, you can change that while you're alive. But once you pass away, your living trust, if you're married, once you and your spouse pass away, those are typically irrevocable trusts. So you cannot change them. Absent a court order, unless you have a trust protector, so absent a court order. So if you have a living trust or special needs trust and you pass away, it's going to be irrevocable trust, so they can't be amended, but a trust protector can change the terms of the trust. Now, what's the difference between amendment and a change? It's slicing your legal bologna extremely thin, but it works. Okay, so this is a respected role in trust law, the trust protector. So this operates, very important, the trust protector operates outside of the court to ensure proper trust administration. Typically, the trust protector has the power to replace the trustee and protect your loved one's interest. Again, the trust protector can amend the trust under certain circumstances to adapt to changing laws or circumstances and really act as a safeguard to ensure that your trust is administered according to its purpose and your loved one's best interest without court involvement. So if you don't have a trust protector, you're going to court. And I will tell you, I have seen firsthand in court, judges take what I believe to be an unfair position. So some judges have said, and I've seen it on the bench, where they say, you know, this special needs trust is taking away health care for children in California, and they see themselves as a revenue agent. And you're thinking to yourself as a lawyer, they're really biased. Okay, I've seen this. You want to keep a special needs trust out of court. All right. I'm telling you, and I've talked to a lot of attorneys who had the same issues with judges who come in with their own bias and their own worldview. This is not all judges, okay? And what I've seen in practice is they really question some of the things that, some of the very important attributes of a special needs trust that are part of federal law. This is like federal and state law, and the sense is that the judge doesn't agree with that for whatever reason. So the idea is you want to keep that out of court. The trust protector facilitates keeping the trust out of court. Letter of intent is not part of the special needs trust document. So whether it's your living trust or it's your standalone special needs trust or your IRA legacy special needs trust, which we'll talk about, the letter of intent is not part of your estate plan. Why do we do it? Because it can communicate your loved one's needs, your intentions, your goals, your expectations, your wishes, if it's your child, for your child. This also can be updated. This is not a legal document, okay? This is something where you're not tinkering with the trust itself. And so whenever you tinker with the trust, when you change it, you should be going to the lawyer. That just runs up legal fees, runs up complexity. And this letter of intent can change from time to time. You can hold a family meeting. So if you're blessed to have more people in your family other than just your loved one with special needs, you can let your family members know what your intentions are and communicate that and make this letter known. Again, this is it's outside of the special needs trust, and it can obviate the need to change the document itself. So oftentimes we'll put in the trust document that from time to time you may have a letter of intent and the trustee is to consider that. It's also not part of the trust that gets sent to the public benefits people, right? So a lot of times if you put these desires in the trust, that can be counterproductive and can cause problems with the public benefits people. Well, let's talk about comprehensive planning. So what am I talking about? So what I'm talking about is creating a comprehensive life care plan for your loved one with special needs. Considering the monthly income, you got to factor in SSI. Again, SSDI, if it's SSDI, then you may not be looking at a special needs trust, but you still may have to provide for the person. Look at Social Security earned and unearned income. Is there any sort of passive income that your beneficiary might receive from an inheritance, right? What are the monthly expenses? The housing, the food, transportation, medical. What about recreation, travel, education, just general quality of life? Life is not getting any cheaper. It's getting more expensive, and certain things prices are going up faster in certain areas than others, certain geographic areas or certain spending areas. And then how do you meet the shortfall? So if there is a shortfall, and really this goes to the question of how much is enough to put into a special needs trust? And we get this quite a bit from clients that we meet with. And again, it's case by case. It's just completely individual. Look at resources. I think it's important to identify all the financial resources available. This can be government benefits, perhaps employer benefits. Certainly, if you're a state employee in California, there are some benefits for disabled children, your insurance, as well as your personal assets. Typically, life insurance is what we're looking at. And focusing on the medical health plan options and coverage. What about Medi-Cal, Medicare? What about Children's Health Insurance Program, the CHIP program, and employer-sponsored plans? and explore resources for managing the care, including online tools, lots of online tools, obviously. And this is very important. Review your employee benefits to determine how they can supplement your special needs plan. So a lot here, and this is typically outside of the scope of what a lawyer would be helping a family with in many instances. So you kind of have to learn this, frankly, because it's very case specific. What about transitional planning? When your child turns 18, we discussed this a little bit earlier, the law will presume competency. So you should plan ahead. So if you know that your child is not going to be able to care for themselves at age 18, you're going to want to start that conservatorship process earlier, right? Earlier than 18. Typically, I would start thinking about it maybe a year before and engage the services of a lawyer who handles that type of conservatorship plan. So conservatorship is basically a guardianship for an adult. And will your loved one need help managing healthcare or other financial affairs? So a loved one with special needs may have capacity to sign powers of attorney. So if you don't take away their ability to contract, if you don't take away their ability to basically be an adult, they might get themselves into trouble, right? And that's the conservatorship. That's the path of the conservatorship. Again, a little bit outside the scope of special needs trust, but related. So if you do have a minor child with special needs who will not be able to take care of themselves in the future cognitively, that's when you look at that. So comprehensive estate planning includes you're creating your living trust. Again, it's a bucket you throw your assets into. That's funding your living trust, is getting your house, stocks, bonds, mutual funds, investment properties in your living trust. Advanced healthcare directive, who takes care of health, who makes healthcare decisions for you. Your pour over will, if anything's in your name, it goes into the trust when you pass away. Deeds to your properties, that's how you put real estate in there. Durable power of attorney, typically that's going to cover IRAs, 401ks, and life insurance and annuities if you have those. And not so much the assets in the living trust. HIPAA authorization gives someone else the ability to access your health records. And then also beneficiary designations on life insurance, IRAs, 401ks, and annuities. Very, very important because those pass outside of your living trust. And we're going to talk about how you can use an IRA, so certainly if you have a loved one with special needs, how you might be able to use the new rules about IRAs to create a significant amount of wealth. It's also to provide for the beneficiary as well. So I would say this is special needs planning in your estate plan in general. Pick a responsible person to oversee your care and resources. So a lot of people, certainly people who have spent a good chunk of their adult life caring for other people, right? Oftentimes don't think about what happens to themselves. So if you've been caring for somebody, maybe you have an adult child you've been caring for since they were born, you may not be taking care of yourself. Well, who's going to take care of you if you can't do for yourself, right? And address what happens to your loved ones with special needs if you can't do for yourself. So if you can't take care of yourself, who's going to take care of your son or daughter, oftentimes, or maybe a grandchild, right? So you typically pick a responsible person to oversee the care and resources of your loved one with special needs when you can't. Care managers can be written into your special needs trust. That's what we talked about a little bit earlier, to serve as advocates for your loved ones. You may also want to consider a standalone special needs trust to provide for your loved one in the event of your incapacity. And here's why. And this is a very important part of our time here together today. If you have a living trust, most living trusts say, I created this living trust. If I am not serving as trustee, let's say I become disabled, incapacitated, those trust funds are used for my benefit. If you have a loved one with special needs, you need to pay close attention to that, because the trustee could take a hard line and say, there's nothing in there for your loved one with special needs. If there is something in there for your loved one with special needs, the problem is if it's not structured as a special needs trust, it can kick them off their benefits. And this is what drives many people, certainly as they age, to create a separate special needs trust that exists before death. So a lot of people will create a special needs trust that springs into life after death. But what we're finding increasingly, especially with older clients, is they're creating this separate trust a lot of times to address what happens if the parent, right, in the parent-child example, if the parent becomes disabled and that child still needs support. So that's why people will oftentimes create a standalone trust rather than just having it all happen at death, right? Review all beneficiary designations, entitling, and ownership. Very important, because if your loved one with special needs is a beneficiary of an IRA, 401k, whatever it is, that's an available asset that may cause them to lose their public assistance benefits. Do you have a business, right? Special rules with business. Does that loved one with special needs become an owner, a part owner? Are they a shareholder in an S corp? That can cause some really bad tax consequences, quite frankly. So that's something, if you have a business, we cover that with the buy sell, and we've covered that in other webinars. Have you documented your financial strategy? Do you have a documented financial strategy? Makes sense, right? So if you say, gee, when I pass away, maybe we should keep these rentals, maybe we shouldn't. Since Prop 19, the properties are getting reassessed. And kind of walk through this and think about a good financial plan of action to support your loved one. And again, this is, I think, created largely in seeking out an A-team to help you through this process. Typically going to be your estate planning attorney, your financial advisor, and your CPA. And it might also be your, other people who are involved in your loved one with special needs life. So when is it time to look at a special needs trust? I think if you look at the award letter, or that an individual is receiving SSI, that's when you need to look at, and you want to leave this person money. Okay, so the person you love, the person you care about, is receiving SSI, and you want to leave them some money. That's when you need to look at using a special needs trust. And again, SSI, supplemental security income, pays monthly benefits to people who are with limited income and resources. So if you leave money to this person, even if you leave them $20,000, it's going to kick them off their benefits. So this is means tested, and really a lot of our clients' loved ones are working, but it's very limited work with SSI. So again, Dolly, a minor, lives with cerebral palsy. She receives SSI and won't work. When she turns 18, she'll continue to be eligible for SSI so long as her assets are below 2,000. So Dolly's parents create an estate plan with special needs trust provisions so that Dolly is provided for, but keeps her SSI and other government benefits. Without this planning, she loses them. So, if that's you, if you've got a Dolly, then I would really encourage you to take a look at special needs planning. So if you're watching this on YouTube, please subscribe to our YouTube channel. And if you enjoy our webinars, please go to Google and review us. You can just type in Cunningham Legal and we'll pop up on Google. And next webinar is October 17th at 12 p.m. We're taking a little bit of a hiatus here. We're going to talk about what is the difference between a will and a trust, going back to the basics. So for those of you who might have a trust and go, why did I get this thing and why is it 900 pages? You might want to check that out. If you have any questions, we'll answer questions right now. If you're watching this on YouTube, just keep watching it on YouTube, because magically the next webinar is going to roll right after this one. And in fact, it may be the Wills and Trust webinar. I don't know, that we haven't done yet. Thanks for watching.